Welcome to When Office Romance Makes Headlines and the legal considerations behind that. I'm Lorena Vasquez, Vice Chair of the Beverly Hills Bar Labor and Employment Section, and I will be moderating today's very exciting program. I am delighted to introduce our speakers, Maryann Gallagher and Ellen Cohen. Maryann is the founder of the law offices of Maryann Gallagher, which has recently joined forces with Jeannie Harrison Law. With over 30 years of courtroom experience, Maryann has secured landmark verdicts in sexual assault, sexual harassment, sexual orientation discrimination, disability discrimination, and whistleblower retaliation cases. Ellen Cohen is the principal in the Los Angeles office of Jackson Lewis, providing comprehensive representation of management in employment disputes. She handles cases involving harassment, discrimination, retaliation, and wrongful termination in state and federal courts, as well as arbitration and administration hearings. Ellen takes a proactive approach in supporting her clients, providing valuable advice on a host of employment issues, including discipline, termination, layoff procedures, accommodations under the ADA and FEHA. And now let's get started.
Great. Thank you so much, Lorena. Today, we're going to be focusing on the legal risks and the duties associated with interoffice relationships. We've got a slideshow prepared for you that has a lot of materials, and hopefully you find it useful. I'll be coming at it from more of a defense perspective, and Maryann's going to be coming for a plaintiff's perspective. Can we move on to the next slide? All right. So again, interoffice relationships in California, while not necessarily legal, they aren't just HR issues. They're really legal landmines. California imposes strict fiduciary duties on officers and directors. There's a duty of loyalty, duty of care and candor. Undisclosed relationships can undermine trust, decision-making, and trigger lawsuits and board investigations. Basically, it's not a good thing. And typically, we advise clients to use disclosure as a shield and not a sword, because it could really get messy. Next slide. All right, so imagine a director who's secretly dating a subordinate. The director doesn't disclose it, and later the employee gets a plush assignment. When the relationship's exposed, shareholders allege the director put personal interests above the company's. This isn't necessarily a hypothetical. This is a very, very common scenario we see where an individual director could be found. There could be liability for the individual officer or director who fails to disclose this relationship, and it affects their decision-making. Non-disclosure can expose executives to personal liability for breach of fiduciary duties, and it could trigger shareholder derivative actions, which are becoming increasingly common in these kinds of scenarios. So again, as a defense attorney, I highly encourage my clients to develop a culture of transparency and regular training. Next slide. So why do interoffice romances make the news? Well, it's definitely more interesting than wage and hour stuff. And it's probably on the juicier end of employment law in general. But there's a whole slew of issues that come with it. There is conflicts of interest. Think of the McDonald's CEO that was ousted for a relationship with a subordinate. That was all over the place. There could be breaches of fiduciary duty. California Corporations Code Section 309 is clear. It says that directors and officers must act in the company's best interest. And this is a prime scenario to kind of trigger those breach of fiduciary duty suits. There's also the idea that a single romance can trigger a derivative suit by shareholders. And of course, there's harassment and discrimination claims, especially if the relationship ends badly. There's favoritism, there's a supervisor-subordinate relationship. So mishandling and hiding of these office romances, especially at the executive level, can have swift and severe consequences, which is why we're here with you today. Next slide. So let's kind of get into the legal nuts and bolts of it. Under the California Corporations Code, Section 309, directors and officers owe a duty of loyalty, care, and candor. There's a case law saying that, showing that a secret relationship can trigger not only the lawsuits we spoke about for breach of fiduciary duty and shareholder derivative actions, along with personal liability, but it could also void the executive's actions and any decisions made by the board as a result. As a result, the board must independently investigate any of these potential conflicts or breaches of duties and document. An executive should always be aware that if they're in doubt, if they think that there may be an issue, if they think that there may be, they may be entering a gray area with respect to relationship with subordinate, the school of thought is, if in doubt, disclose and recuse. If there's any issues, always disclose and recuse. Next slide. So here's another scenario. A senior executive at a company starts dating a subordinate. Doesn't tell the board, but he's involved in promotion and pay decisions with respect to the subordinate. Other employees notice, morale tanks, the whistleblower tips off the board. The company investigates, and the shareholders allege a breach of duty. This is becoming an increasingly common scenario, especially as social media becomes more prevalent. People have more contact with one another. They're able to communicate offline or at work and socially a lot easier, which is leading to more and more of these situations. Courts have held that directors and officers must fully disclose any personal interest, even if they personally think that it's not an issue. If there's any personal interest involved, that could, in theory, impact their impartiality. Even if they think it doesn't, if in theory it could impact impartiality, it should be disclosed. This is supported by multiple court rulings, findings, things like that. As a defense attorney, we typically train executives and HR professionals about disclosure obligations, how to document, how to train, so that, and establish a process for recusal and disclosure so that we don't get to those issues. Next slide. So in general, undisclosed office romances can lead to all kinds of conflicts of interest, especially when you are dealing with executives. It could not only lead to personal liability, it can actually void the transactions and cause severe reputational harm. Next slide.
So I'm going to talk about damages. Where's the money in these first type of cases? So in the shareholder, in the individual liability, it's shareholder versus individual. It's really between the corporate players. So the shareholders will say to the person who had the relationship, either you didn't disclose it to us and you caused us harm, or you disclosed it to us, but you didn't follow our procedures and you caused us harm. So that's the first type of case, would be the shareholders suing the individual. A lot of the cases on this are about where shareholders are stealing other people's employees, like they're getting ready to resign and they're taking a bunch of people, hey, come along with me. So those are the kind of the examples that they're using, where under what Ellen was talking about, which is the corporate code 309, you can't put your personal interest ahead of the shareholders. So the remedies that you can get, which would again be the individual corporate director or officer having to pay back the shareholders, is disgorgement of their salary. So if there's an issue where, I guess in the harassment case, the scenario would be if he's having a relationship with somebody and during this whole period of time, he's either not disclosing it or he's abusing what the board is telling him to do, then he would have to pay back the money that he made from that period of time. So the disgorgement of salary, that's under 160 Cal 4th 362. So that's one remedy. And then if we go to the next slide, not only that, but shareholders who say our corporation has been damaged because of what this person did, everything's open to them, just as if it were a tort. So they can get reputational damages, they can get fraud damages. They have a whole basket of money that they can go after. But again, from the plaintiff's point of view, we don't represent corporations usually. We don't represent shareholders, and going after an individual, especially after he's lost his job, isn't going to be like the place that we want to go. So I can see where this violates the law of the fiduciary duty between the executive and the corporation, but from a plaintiff standpoint, it's not a place that we would be looking at unless we represented the corporation to go after the individual. And then even then you have to think, are we going to recover? And how much money are we going to be able to recover from this individual? That's our individual liability.
All right. So still talking about the executive level employees, how do you manage these conflicts of interest? What are the best practices? From a defense perspective, and this is what I typically tell my clients, the best way to manage this risk is to have clear and consistent policies and enforcement of those policies. This is what you're expected to do. This is this is what you can do. This is what you can't do. And if you did it, here's how you fix it. Disclosure to the board and shareholders is required. It's always required. And recusals from decisions that may affect your recusal from any decisions affecting your romantic partner is required. Otherwise, you're really opening the door up for a lot of legal consequences. So again, if an executive is in a relationship that could create a conflict, disclosure is the first key to the board and to the shareholders. Then the next step would be recusal. How do you do that? Who do you talk to? There have to be clear policies, consistent policies, and how that's enforced. Step away from any decisions involving the romantic partner and anyone that could be closely affiliated with the romantic partner. For example, a best friend, a family member, anything that may be tethered to that romantic partner. You should also consider recusal. The other very, very important key here is documentation, documenting that disclosure process, investigation process, and recusal process. Recently, I actually had a case where I worked with a company where an executive disclosed her relationship, recused herself, and then the board documented everything, steps were taken. Later, the transaction was challenged. There was a lawsuit involved. There was all kinds of things going on as far as the steps that this executive had taken while involved in the relationship. But because this executive timely disclosed that relationship, recused herself early on, and it handed the reins over to someone else, that some of those decisions were ultimately upheld as fair, and things were able to move forward as the company had intended. So again, the disclosure and the recusal process isn't just formalities, it's required. It's the best defense that we have as defense attorneys for litigation. Otherwise, the door is just open and there's really not much you can do there. And with it comes a written formal process for handling those disclosures, recusals. Okay. So danger areas. That danger areas, there's some very, very obvious ones: promotions, compensation, disciplines involving your romantic partner, influencing over hiring and projects, those sorts of things. But there could also be those very slight, appearance of favoritism or bias. You may not be, or the executive may not be intending to exhibit favoritism, may not necessarily be giving the promotion, but you're being invited to lunches, you're getting concert tickets, you're getting, better seat at the conference, things like that. And those are the scenarios that trigger these kinds of lawsuits. So again, you're looking at the very obvious scenarios, but also you have to look for the, is there favoritism, something that may not be as obvious. And if the executive doesn't disclose, that's where we come in for defense. There's personal liability for the executives. As Maryann noted, there's going to be reimbursement for unfair gains. There's damage to the corporation and trust, which ultimately becomes one of the biggest issues for these companies we're working with. It's much easier to reimburse for unfair gains, for the most part, but reputational harm is something that stays with you for a very long time. Next slide. But again, not all workplace romances create a problem. There's times where it's really, it is what it is. It's just part of life that people spend most of their adult lives at work. So these things happen, and not every single one of these instances will create a legal problem. For example, if two employees in different departments start dating and they don't report to one another, there's no subordinate supervisor relationship, usually there's no legal issue. And I say usually because you never know. There's always facts that could pop up. Really, where these issues come up is where there's a power imbalance, where you've got someone that's got the ability to influence the other person. And in situations like that, that's where the California Corporations Code that we talked about kind of comes in, especially when it comes to these, shareholder board actions. And we'll talk more about romances when they're not a problem in the context of the FIHA. Next slide.
So I think this is me, but Ellen, I just had a question. Does HR contact attorneys when they're talking to these executives about how to do this, or is HR handling it on their own?
We get contacted fairly frequently with these sorts of scenarios. And thankfully, at least the last couple of years, we've been contacted early on. I mean, obviously, we'll come in when the lawsuit happens, but we do provide counseling. And HR is very, 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 it seems like, at least with the more sophisticated companies with HR departments, it seems like that's something that's on the radar. Typically, if there's a disclosure, we'll typically get looped in.
And you would prefer that to happen? You would prefer that HR contacts legal instead of trying to handle this on their own?
It certainly helps us down the line if we have to defend a lawsuit.
So we're going to talk about harassment and discrimination in California law and how some of these scenarios fit into our harassment. So we've got the FIHA, the Fair Employment and Housing Act, which basically provides the basic law. It's 12940 government code. So there's strict liability if the person who's doing, as Ellen referred to as there's a disparity in power. The person who's doing the harassment is a supervisor. He's got the power over the person he's harassing. So there really isn't consent. I don't think there could ever be consent if you got like the president of the company, having a relationship with a younger woman that he controls and that he can decide what to do. So that's Department of Health Services versus Superior Court. So supervisors are always strictly liable, corporations liable. There's no escaping it. That's always the big fight in these cases. They're always going to be making a motion for summary judgment. They haven't been doing them anymore as much in harassment cases, but if they do, that's where they're going to focus. So when you're talking to your client for pre-deposition, you have to make sure you're talking about how this person had power to control what she did, like he told her what to do during the day, and he had the power to say whether or not like she would get a raise. Maybe he was involved in her reviews to show this imbalance of power, which is really what the strict liability is focused on.
Now, if I can interject, as a defense attorney, we counsel our clients and we look at it from a different perspective. Was this person truly a supervisor in a way that would trigger the strict liability standard? And if that person didn't necessarily control the material terms of this person's position, they didn't control scheduling, they didn't control, hiring, firing, performance review, things like that. We look at all those things in order to see if we can establish this person was not in fact a supervisor in order to avoid that strict liability standard. But it is a major issue in all of these cases, whether or not the person was a supervisor as defined by the FIHA in order to determine whether or not strict liability applies.
And that's why it's such a fight, because you're either going to have the individual harasser on the hook or you're going to have the corporation on the hook. So if he's a supervisor, the corporation's on the hook. And
in fact, Maryann, you and I had a case with a similar issue against each other where we had that same argument.
So you need to talk to your clients about this on both sides. They need to know it is a question of fact eventually, for as long as you have facts on both sides for a jury to decide. And then there's the negligence standard. That's if you have coworkers and there's the company knows about it and they have to take immediate corrective action. So it's immediate and it has to be geared toward preventing further harassment. And that's Myers versus Trenwith. That's a little bit harder to prove, but if there is a pattern in the company and sometimes there is, of harassers, going after multiple women and using their power to get them to go out with them and promising them that they'll, give them better shifts or they'll give them a raise, that's the coworker harassment. That's he might not be the supervisor per se, but if he has a trend of doing this and other women are coming forward and the company isn't doing anything, then that's the negligence standard. And then personal liability, the harasser is liable personally for the harassment. If we can get the strict liability or the negligence liability on the company, they're liable as well. But the individual is liable for harassment, but they're not liable for discrimination. Only the company is liable for discrimination. So these are some of the cases that are out there. So there's two different kinds of harassment that you can prove. Quid pro quo is if the supervisor conditions benefits on going out with him or having a relationship with her, or if the employee feels pressured to continue with the relationship to avoid negative consequences, to avoid being fired, to avoid him reporting her, then that's quid pro quo sexual harassment. And then hostile work environment is quid pro quos pretty much, it is, you know it when you see it, because there's either statements that say, hey, you know, if you sleep with me, I'll make you HR, head of HR. Or if you don't sleep with me, you're not going to become head of HR. So that it's usually the words that you're looking at, but it can also be words and conduct. The law says if he is pressuring her, both with words and conduct, bullying her, yelling at her, freezing her out if she refuses to engage in his sexual affair, excluding her. I've had cases where like she'll be sitting in a meeting and there'll be 5 people in the meeting and he'll talk to everybody except for her. He'll give assignments to everybody except for her. So it's conduct as well as statements. And then hostile work environment that's where there's it says widespread favoritism, rumors, or resentment among employees. employees. So the issue is whether it's severe or pervasive enough to alter the conditions of the employment and create an abusive environment. And the law has come very far and wonderfully in the direction of hostile work environment and what severe or pervasive means. So we have our Casey standard, which says that one incident is enough, is sufficiently severe or pervasive to constitute sexual harassment. And that's Casey 2524. And that comes from the recent government code enactments. It's recent, it's probably like a few years out there now. And that's government code 12923. And that's where the court really took a look at this hostile work environment. What do you need to prove the severe or pervasive and how it affects the conditions in your environment. And it says government code 12923B is which says a single incident of harassing conduct is sufficient to create a triable issue regarding the existence of a hostile work environment if the harassing conduct has unreasonably interfered with a plaintiff's work performance. So that's why and even the cases in Nazir, it's NAZIR, says that hostile work environment cases are not really should be a subject of a motion for summary judgment. So we're not seeing, thankfully, a lot of motions for summary judgment on these. And then it talks about what the workplace should be like. What is going to tell us what's severe or hostile? And then government code 12923D says a legal standard for sexual harassment should not vary by the type of workplace. It is irrelevant that a particular occupation may have been characterized by a greater frequency of sexually related commentary or conduct in the past. Like there were cases about writers for Friends or people that wrote for these sexually charged shows. And they said, well, we use that language all the time. So what is this person complaining about? Well, the statute says, no, you can't just hide in the midst of these jobs a person who's being sexually harassed. And it says, in determining whether or not a hostile work environment exists, courts should only consider the nature of the workplace when engaging in or witnessing prudent conduct, and commentary is integral to the performance of the job duties. So they're basically saying you only look at the workplace if what the words that were being said, like in the script issue where they were using words for a script. Okay, if it's words for a script, that's integral to what they were doing. So that's not really harassment. But if you're talking about a script and then he's saying, hey, her boobs are bigger than your boobs, or they go further, then that's kind of where the line is drawn. That's why all of this is fact-centered, and it's not really the subject of a motion for summary judgment. And then 12923 government code A talks about what is hostile or offensive or oppressive, intimidating work environment. And it says it deprives the victims of their statutory right to work in a place free of discrimination when the harassing conduct sufficiently offends, humiliates, distresses or intrudes upon its victims so as to disrupt the victim's emotional tranquility in the workplace, affect their ability to perform their job, or otherwise interferes and undermines with the victim's personal sense of well-being. So that's really, I try and tell people, like if you're going to work every day and you're driving to work and this guy, Joe Schmo, is driving next to you and you're being harassed, from the time you leave your house, you're in your pit of your stomach. Oh my God, I don't want to go to work. Like, what's going to happen to me today? Is he going to say something to me? Am I going to be in trouble? And Joe Schmo, who's not having any sexual harassment, has none of that. So it's kind of, it's very fact specific, and you have to delve into these facts with your clients and talk to them about, how do you feel when you're driving into work? How does it feel? Sometimes they'll say, a lot of my corporations will move a person, they'll move the harasser, but they'll move them like, he's still in view of this lady. He walks by her every day. Oh, we moved him. But how does that make her feel? Does that, when he's walking by, does that disrupt your ability to concentrate on your job? Are you afraid that he's going to do something to you? So those are all fact-specific information that you have to bring out from your client when you're talking about a hostile work environment. Okay, so let's go to the next one.
Wait, Maryann, I
Okay.
have a quick question for you.
Uh-huh.
In your practice, and specifically in the context of workplace romances, do you typically see more quid pro quo harassment claims come through or hostile work environment?
Mine's much more hostile work environment. Like I think that's more, because quid pro quo everybody's pretty smart right now. Don't be saying bad things at work. So they're not really saying the language. And again, that's easy. Those are great cases, and usually they settle pretty fast. So those aren't really litigated as much. The hostile work environment is the hotbed of, because there's these, is it a supervisor? Was it severe or pervasive? Those are the facts that really have to depend on what comes out in the case. So that's why I think I see a lot more hostile work environment.
I think from my perspective, I think we're seeing a pretty good balance of both.
Really?
You've got, the I'll promote you and then someone's upset about it. I think quid pro quo is a big one. I think that it probably is the same rate at hostile work environment. So it's interesting that you're seeing more on your end of the hostile work environment.
Yeah, the quid pro quo, because they have to do their training, their supervisor training. They show the videos with these little scenarios. So I think they're getting a little bit more, supervisors at least are getting a little more, informed as to how to say things or how not to say things, or how to make it look like it's not quid pro quo. So that's why I think that's where the fight is usually on the hostile work environment. So then another form of sexual harassment is sexual favoritism, and this kind of comes into what we're looking at with the Coldplay, the whole Coldplay incident. How many different lawsuits lie in that little scenario of the concert? So you got, of course, her suing him, the shareholder, because he's the big CEO and he, I guess, hired her, so he has control over her. That could be quid pro quo sexual harassment. Sexual favoritism could be all the other people that are in this, working with these two people, if he's showing preferential treatment to his partner, then the other employees around have harassment claims if it's widespread or severe enough to impact the workplace. So this applies to men or women. Women can have complaints for sexual harassment based on hostile work environment, sexual favoritism, if the boss is favoring other women and promoting them over you. The case on that, there's Miller versus Department of Corrections that we have in there, is it's a good read because it's got all different kinds of, like, what was going on in this place is just crazy. Like, the guy was the warden of a prison, and he's having affairs with 3 different women at the same time. And then Our Lady Miller is seeing all this going on. She was up for a job with somebody else, and he promoted the other person over her. She complained. They didn't do anything about it. So, and then all the women started fighting amongst themselves, and Our Lady's has to deal with all this going on at the workplace, which that's what it is widespread, because it happened. I think that went over like the course of 2 years, but that was a woman suing for sexual harassment, hostile work environment based on sexual favoritism, when it was a man dating and using other women and basically promoting them over her. So in Miller, it says even though what they're looking at is that the hostile work environment, it sends a demeaning message, which is conveyed to female employees that they are imbued by management as sexual playthings, or that the way required for women to get ahead in the workplace is to engage in sexual conduct with their supervisors or the management. So that's how they define the sexual favoritism. So that is a really good case if you have a hostile work environment, if you have a woman with other women who are being given preferential treatment over her. Men as well, men can do it. Like in that case, the Coldplay case, everybody who worked under that HR lady in HR and anybody who was up for promotion or didn't get a job because she got the job, they all have complaints. And then we've got retaliation. We're going to talk about, I think, a little bit more with Ellen, and morale issues. But a lot of times these claims all lead to retaliation if an employee ends a relationship and then she gets fired or her boss does something to her, then that's retaliation. Or if another employee complains about this going on in the workplace, and then that employee gets either demoted or they get fired. And then, as Ellen mentioned earlier, it undermines morale and productivity and fairness in the workplace. So that's basically the hostile work environment, like the sexual harassment part. We can go to the next. Do we have next one? So now the employer has a duty to take all reasonable steps to prevent harassment and to act promptly when it occurs. And this is particular in the context of office romance, as Ellen was talking earlier, where the risk of harassment and favoritisms are heightened. So this is a great case, Jones versus Donovan Correction Facility. And again, there's two duties: to investigate and to take immediate actions to prevent further harassment. I think a lot of times we see an investigation occur and we always hear unsubstantiated because it's just the harasser versus the harassee and nothing's done. So the guy goes back out there. That, I think, is always ripe for us to argue that they should have done more. They should have talked to other witnesses. They should have done something to make sure this woman was protected. But it's kind of like once an employer finds unsubstantiated in HR, they're like, okay, we're good. We got like our unsubstantiated stand and we can like go on with the case. What do you think, Ellen?
Well, I think, again, it depends on what the policies are and how the investigation's conducted. If you have a situation where HR is trained, a complaint is made, witnesses are interviewed, the process is followed, and ultimately the result, interviews are conducted, steps are taken, and ultimately the finding is unsubstantiated. And we're able to use that in our defense of these cases. Like, hey, look, here's the person here's when the complaint was made, here's how it was investigated, here's the timeline, here's how we got to that finding. I think that, you have what you have. But I do agree that there's times where that stamp is used of unsubstantiated, but it all comes down to what are the policies, how are these folks trained, and how is the investigation conducted. I think that if all those underlying things are met, I think that that unsubstantiated stamp is warranted, and it's, the defense that employers can invoke to support its, findings.
That's again another area ripe for discovery when we're taking the cases. If we want to get the investigation file, we want to see who they interviewed. You want to go through their policies and procedures are always great. They've got these great, because Ellen and all these great lawyers write them and say, we don't tolerate any sexual harassment. We have a zero tolerance policy. But then here we go with Our Lady, and that's harassment. And why are you tolerating that? Like, why aren't you taking any action against this guy? So it's a huge, huge issue in discovery.
And that's why I agree with you in that summary judgments in these kinds of cases are tough, because it's very, very factual and there's always a plethora of disputes. So I think that it really comes down to those small details. Who was interviewed? When were they interviewed? Who made the complaint? When did they make the complaint? How was it? Who investigated it? How was it investigated? And the documentation. It comes down to documentation.
And there's a case on our side. It's the Department of Health versus Superior Court, 31 Cal 4th, 1026, that talks about looking at if there's an investigation And let's say they say it's not substantiated, but then the person gets retaliated against. They either get demoted or they get terminated. Then that case says that if that is what's taking place, future victims will have a strong argument that the policy and the grievance procedure did not provide a reasonable avenue for the complaint. So if you can attack that point, like, okay, maybe you did an investigation, but then this person got retaliated against anyway. So your policies are not providing the protection that they should be providing. And then, and I think this is more where employers are permitted to regulate workplace relationships for legitimate business reasons, such as supervision, safety, security, or morale. I don't know, Ellen, do you ever get arguments from people that want to have a relationship that you're not allowed to tell them what to do?
No.
I couldn't imagine that happening.
By the time they get to us, we're not there anymore. we're past that.
So you're allowed to have anti-fraternization policies. You're allowed to require employees to disclose romantic relationships for management so that the employer can take steps to manage the conflicts. You're all allowed to do that. Let's go to the next slide, because this one this was Ellen's, which I've never heard of before, love contracts. I wanted to hear all about love contracts. I'm like, I've never heard of that before. So could you tell us about love contracts, and do they exist?
With these love contracts, we're actually seeing them a lot less now. Basically, it's an agreement that both parties acknowledge that they're in a romantic relationship. They acknowledge that the relationship's consensual. They reviewed the anti-harassment policies. They agree to report any future concerns or issues. And this can be used by employers to, protect themselves if the relationship later ends and they say, I'm being sexually harassed, this person was forcing me into a relationship, I didn't consent. But at the same time, if you have a situation where one of the parties to the employment contract is a supervisor, or the love contract, excuse me, then really you've got an imbalance of power and how voluntary was that contract for the subordinate. So we're seeing them less and less. Some companies are implementing them. I think if done correctly, it could serve as, base for a defense for employer for a sexual harassment claim. But I get nervous about them because it comes down to the facts and how, who is involved in the contract, how was the contract presented, things like that. I think what it really comes down to is training, documentation, communication, and including something in that contract, or just making it well known that if there's an issue, if your things have changed, if there's a problem, doors open, and there have to be multiple channels to discuss those issues and address those issues. But I think love contracts are iffy, at least for me. I think that if done right, it could be successful, but there's a lot of issues that can go along with it.
What if let's say it's a relationship and the one person says, I don't want to sign the contract? Do they have to sign a contract in order to proceed with the relationship, or?
You don't have to sign the contract again, but it's all situational. I don't think you have to sign the contract to proceed with the relationship, but it depends on what the company's policies are. Two, who are the people involved? Are they two coworkers? Do we have a supervisor? So I think it's very, very situational. And I think that's why some of these love contracts or these consensual relationship agreements, I don't know how useful they are in a lot of scenarios. I can't see it. For example, this astronomer scenario with the CEO and the HR person, they could have had a love contract, but in reality, you've got the CEO and the head of HR, and got a big problem here, regardless of whether or not they say it's consensual. So I'm iffy on them.
Have you ever heard of anyone using a love contract as a defense where a sexual harassment case was brought?
I have, in that they disclosed it, but this was a situation where, first of all, it was a couple of years ago. I haven't seen one for a while, but in this situation, it was two coworkers. They were in different departments. They were both executive level employees, but they didn't work directly together. And in this case, they disclosed it very early on. They signed this contract. Obviously, because it came to me, things that ended badly. And one of the parties to the love contract was not happy and sued for sexual harassment. But we were able to rely on that love contract in that instance because they disclosed it early on. There was a lot of communication. They had the same power at the company and they didn't work directly together.
Interesting.
But I haven't seen one for a while. How about you? Have you had one in any of your cases?
I've never heard of it before. That's why I'm like, I never heard of this contract thing. Like I never heard of anyone, even like a company even offering it to any of my clients. And then, so I think training and communication that's what Ellen's talking about from the company side, is making sure that you have the anti-harassment policies and talking to them and making sure that the employees understand the procedures for reporting if they have concerns. And again, for us from the plaintiff side, that's information that we want to get in discovery. We want to see what their anti-harassment policies say. We want to see how they ensure that the employees know where to report, because sometimes it's not as clear, or who to report to. They're afraid because the person harassing them is a supervisor, and usually the policy says report to your supervisor. But I know policies have been updated and now they're saying report to your supervisor unless he's the person that's doing the harassment, then report to the person above him. But still, for a lot of my employees are like factory worker women, they're not going to go above their boss's head to report them. So that's always an issue that we have. Can we do the next slide? Scenarios. I think these are, Ellen, these are yours. We can talk about these together.
Oh, sure. I mean, these are just some the scenarios that you come across in these sorts of cases. The supervisor that dates a subordinate, there's a breakup, denied a promotion, retaliation. That's where you get a lawsuit. Favoritism amongst team members. You've got the rumors where things end badly. You've got people spreading rumors about one another. The affected employee files a harassment complaint. You've got the unwelcome advances. These are all just some common scenarios that you see frequently in these kinds of cases. But at the end of the day, I think that policies and communication and that open door and having different channels of making complaints and communicating those things is kind of where what we look at. Because ultimately, if you've got policies that address these sorts of scenarios to the best ability, I think that's where these can be curtailed. But this is what you would typically see. Next slide.
And then the consensual relationship starting out and then turning sour, I think is a big, that's with the supervisor, that can lead to quid pro quo complaints where everything starts out good. Maybe they even have a love contract and then things turn bad and they break up. And I think that's like, I don't know how that would work. Like if you went to your HR and said, hey, I broke up with this guy, he's my supervisor, can you protect me? Like, would HR take proactive steps to make sure that you're not getting harassed or retaliated against? And normally that doesn't happen. Normally the person who is broken up with and the supervisor, the person who's broken up with, is too embarrassed to say anything to anybody. And then having to spend time with the supervisor. And I think it's just, I don't know how you can get around the person who's broken up with, let's say the supervisor man, taking action against the woman who rejected him in however ways that it is subtle, not so subtle, just trying to get her away from him. So that's, I think, why what we're talking about is these relationships are so ripe for litigation, even if it's consensual, even if it starts out consensual. And my point always is it really consensual when you have a supervisor with a high person in power and somebody who doesn't have a lot of power in the company? I don't think those are truly consensual, because I think the person we have single moms, this is their job, they can't afford to and that's the people that they target. They can't afford to lose their job. So these guys are like, okay, you have to do this for me and I'll promote you. So that's always, whether that is truly consensual or not, is a big fight. Again, factual issues, and you have to delve out the facts with your client and talk to them about why did they do this, even if the supervisor is saying it's consensual. One of the things, Ellen, that always gets us on these is the text messages. The text messages back and forth can be, it varies. Like sometimes I'd get ones where the guy's, send me a picture of yourself. And then she would say, ha ha, or she would put smiley face emojis were the biggest things. Like whether a smiley face emoji is consent or not was a huge dispute when these first came out. Look, she's sending a smiley face. She obviously consents to what he's saying to her. She didn't have to respond at all, or because she could have said, I'm offended. Well, who's going to text that? Nobody's going to text it. Like a smiley face is just kind of a way to, a vanilla way to respond without rebuffing him. And that, again, comes through with your client. Why did you send a smiley face emoji? The ones with the kiss, the smile with the kiss. That was like the next level up. Okay, it's not just a smile, it's a kiss. So all this stuff comes into consensual versus non-consensual. Is it truly consensual? And it's a lot of discovery. So always get your client's phone. Make sure you look at all the text messages and see what's going on. Instagram, there's might be pictures out there of her and the supervisor at lunch or dinner. He's got his arm around her. He's like, look, we were at lunch and it was consensual. And she's like, what was I supposed to do? Like, am I supposed to punch him in the head and say, hey, don't touch me? So that's all, again, facts that you have to gather early on to see how strong the issue of consent or non-consent is.
And it's messy. It's time consuming and it's very, very, very messy. And it's emotional. And the people involved have a lot of hurt feelings. And it's probably the toughest cases that I handle because it's so, so personally messy for the people involved. People are hurt, people, sometimes are embarrassed. There's different things that come out. And I think that because of that, a lot of folks are hesitant to really come forward about it one way or the other. And that's where it gets more complicated with HR and when did HR know and when did they investigate? But I think these are some of the toughest cases out there because it is so personal. Next slide. And this is what we just spoke about. If the relationship ends badly, folks, upset, you have to figure out how you're going to separate them, what you're going to do, whether or not retaliation kicks in, whether or not there was harassment. And really what I always counsel employers do is have clear policies, take prompt action, document, help mitigate the risk. Because at the end of the day, as an employer, you may not have access to the text messages, you may not have access to these people's Instagrams, but what you do have access to is company resources and the ability to investigate, to look into it, to implement policies and have that open channel of communications. Next slide. And we've touched on this over and over and over again, but really the supervisor-subordinate relationship, that's the hotbed of legal activity when it comes to sexual harassment, at least in California. I know Maryann agrees with me. This is something that we're constantly addressing with respect to these kinds of claims. This is where legal risk really, really skyrockets. For example, again, a supervisor starts dating a direct report, later approves a promotion. Another employee alleges favoritism. So the direct report isn't the one actually making the claim. Now you've got others that are saying, well, I should have gotten that promotion. I was more, qualified. Why not me? You've got a problem there. The breakup scenario. Now you've got, hey, you broke up with me. What are we going to do here? I'm getting less desirable duties. And again, this is where disclosure is key. These love contracts we talked about, I don't know. Some folks use them. It was probably more prevalent several years ago, not as prevalent now. But one of the things that we recommend or, like these, one, what is HR doing about it? Two, what is the training and what steps are being taken? Sometimes it's not a matter of terminating someone, it's a matter of separating them. But is that separation actually meaningful? Are they still, working in the same area? Are they still walking by each other every day? Are they still sharing, break room? Are they still parking their cars next to each other? So it's very, very fact specific. Next slide. So the key takeaways are this is the most legally risky kind of scenario where you've got that power imbalance, even if that relationship starts out as consensual. I think that I view it a little bit differently. I think there could be scenarios where it is consensual. I've seen scenarios where it's truly consensual, but it's very fact specific and it's tough. You have to really look at you have to look at everything. You have to look at job duties. You have to look at the people involved. You have to look at the personal text messages, emails, Instagrams, and it's a lot. So again, like with the executive level employees, early disclosure, keeping that channel of communication open, ensuring that lines aren't being blurred at work with respect to benefits, duties, motions, things like that. That's where it's key. And we always counsel our clients, update your policies, make sure you're training managers to recognize risks associated with these imbalanced relationships. Whether you're the manager in the relationship or not, you need to know what to look out for because it could really cause a lot of issues.
And Ellen, Gabrielle has a question regarding these love contracts or the agreements of disclosure.
Mhm.
How do you handle confidentiality if you have two married couples. They're married to somebody else.
Well, married to someone else as in,
Like each person is married to somebody, and
oh,
they're coming to you, and you know that they're married. They're like, we're going to have a relationship within the company, and you're going to have them sign off on having
at the end
extramarital
of the day,
relationships.
I personally haven't seen a contract like that. As I said, I haven't seen them in a while, but what I would say is this: it's not the company's job to regulate the marriages of these people, right? So what you're looking at is what is happening at work and how is it affecting the workplace. So for me, I think it wouldn't go to, are you married? Are you married? Because we're not, that's not really within the scope of the workplace environment, unless the two other individuals are also working there. And then you've got a whole other slew of problems. But I think that it would be a disclosure of a relationship between two people that are working together. So it wouldn't go to, I'm married and she's married or he's married, whatever. It would be, I'm having a relationship with this person. I'm disclosing it to HR.
But I wonder if during a divorce, if they could ask the company for any disclosure relationships, they could find out when the relationship started. That would be good for the divorce case.
Yeah.
Let's go to our next slide, off-duty conduct. So off-duty conduct is still harassment. I think one of the cases is a guy was at home and he sent a picture of his down there to a woman and she was at home. He was at home. That's still considered harassment. The boss making you go to a party after hours and then making you drink too much and then going after the woman, that happens a lot. That's still harassment covered under the protections. So it says after hours romance turns sour, two coworkers date outside of work. After a breakup, one starts sending harassing texts and posting negative comments on social media. The other feels uncomfortable at work and files a complaint. Yes, the boss, the company should step in and talk to that person because she's saying that I feel uncomfortable at work. It's affecting me at work, even though he might be sending them after hours at 2:00 in the morning. She still has to be with that person and see him all the time. It's kind of like the Coldplay thing. Again, that was an after hours event that these two were at. The employees that were there can claim that that was offensive to them, and then it affected their work environment when they had to go back. And she's getting all these extra promotions, and she's coming down on them for things that she's doing with the boss. There's such good facts and everything that evolves around that case. Party fallout: employees attend a weekend party where a romantic relationship becomes public. Rumors and gossip follow, leading to workplace distractions and complaints of favoritism. Online interactions, that's where they're sending text messages and all kinds of things after hours. Some they share with other people, creating an embarrassment in a hostile work environment. So those are all kind of things that off duty, it bleeds into the work environment. So that's the key is it making this employee feel during the work hours that it's impacting her ability to work? Are people spreading rumors about her and something that happened at a party? Are people spreading rumors about him giving her favoritism? All those kinds of things can lead to, again, a hostile work environment, and they are still actionable.
I will say that every year around January, we get a slew of calls and inquiries and issues brought to us relating to holiday parties.
Christmas parties.
So, every year we know January is going to be all. And it's something that it's prevalent. You've got the open bar, you've got people socializing together, but more than that, we're seeing the online interactions bleeding into work. And I think that's becoming more and more prevalent as people they're online. A lot of them are working remotely, and that's how they're communicating with one another. So we're seeing a lot more of that. And that's why there's new training, kind of policies being put in place, specifically dealing with online interactions at work and outside of work.
Let's go to the next one. Oh, we've already got, so we can go to the next on retaliation.
All right. So retaliation, I see that we're kind of short on time. We're almost out of time here, but retaliation can be as serious as the original misconduct, as Maryann had said, and it's strictly prohibited, obviously, under the FEHA. For example, if an employee reports a supervisor's inappropriate relationship with someone else, and then is excluded from meetings, that's a form of retaliation. It doesn't have to be the person in the relationship making a complaint. Retaliation can include things like demotions, exclusion from events, undesirable assignments, termination, but it could also be these subtle things like not, ignoring them, not speaking with them, not inviting them to sit together for an outside lunch, things like that. It could be subtle. It could be obvious. It could be very, very subtle. And employers obviously have an obligation to protect their employees from retaliation under these circumstances. If someone brings a complaint, then the employer now has a duty not only to address that complaint, whichever way is appropriate under the circumstance, but also ensure that that employee is not being retaliated against. Next slide. And again, as I had mentioned, retaliation can be as serious as the original misconduct, and this could result in significant liability for employers, because even if they don't find there to be underlying wrongdoing, if that person brings a good faith complaint then and is later retaliated against, there's a whole different cause of action for that conduct. So the employer needs to make sure that there's open reporting, that employees know that they can come with any issues, and retaliation won't be tolerated, and also documentation, always documentation, policies and documentation.
And I think for us, from the plaintiff side, the most important thing is retaliation isn't just termination. It's not just the final act. And like Alan was saying, and we've got samples in here, excluding people from meetings, prohibiting them from applying for other positions, turning them down for promotions. They'll come up with all these other reasons justifying why they did these things, but the court looks at the timing. Did you make a complaint and then within a time period? And it could be up to a year, because it can be longer than a year. But if you have a great track record of work and then all of a sudden you make complaints and then you're all of a sudden the worst person, you're getting written up, you're not being invited to meetings, you're being denied promotions, those are the strong factual allegations that you look to for retaliation before the termination happens. Sometimes we might have cases where we're suing in the middle of a sexual harassment case and then they fire the person. So you have to make sure that you add in your claim for retaliation for the termination as well, and file your DFEH and make sure that's included, because it can snowball even during in the middle of litigation, both for witnesses and for victims of harassment.
And even though it could be subtle, I just want to add, we've seen scenarios where someone will say something like, well, I made a complaint and then they didn't save me the onion bagel for bagel day, and it's because I made a complaint. So it's factual, but there's also things that the complainer can identify that's not necessarily tethered to retaliation. So it becomes a very, very, very fact-specific inquiry, which again, it makes it difficult to really parse out. I think like the sexual harassment claims themselves, was there an adverse action taken? Did something happen to you because of that complaint? I think it's difficult in certain circumstances when it's not as obvious with the demotion or the write-up or the termination.
And I think the other important point that Ellen made was even you don't have to prove the underlying action. You don't have to prove that this was sexual harassment. You don't have to prove that this was hostile work environment. You just have to prove that you had a reasonable belief that something was going on. And if it turns out that it wasn't, you still can't be retaliated for making the complaint. You're still protected.
Next slide. Now, again, we've touched on this before. Not every romantic relationship at work is a violation. It's not something that can lead to a lawsuit. For example, if you've got peers in different departments with no power imbalance, the legal risk is very limited. But again, you're looking for transparency. You're looking for policies in place to ensure that if there is a conflict, if there's an issue, there's someone to talk to.
I think what Ellen was talking about from an employer standpoint is beefing up your employee manuals and your policies for electronic. How do you guys do that? Like, how do you monitor their off-duty electronic text and Instagrams and stuff like that?
You can't monitor those, but you can have policies, for example, for a certain conduct off-duty on social media that may impact poorly on the company. There's different things that you can do, but obviously you're not going to be monitoring people's email or personal emails, personal text messages, but you can have policies in place, say, prohibiting certain conduct outside of work.
When you guys do investigations, do you always tell the HR people to get their text messages and their social media during the investigation? Because that usually tells sometimes a different story than what anybody's saying.
It depends.
I always want to know.
It
So
always
that's,
depends. It depends.
I would always say, I would always want to see what's on there because you can see so many different things in what somebody's telling you face to face. So I think we're almost out of time. We're at 1 minute.
So, if you guys would like, we can keep going through the slides, or would you put it end here?
I think we're pretty much, we touched on everything that we need, I think. Is there anything else?
I think we just kind of go to the key takeaways, and you'll be getting the materials which have everything that we've discussed. There's information in there about potential defenses, for example, pre-existing relationships. They're not necessarily problematic if an employer took care to prevent and promptly correct the harassment and the employee reasonably failed to use the complaint procedure. That could be a defense, but it really comes down to the facts, the policies, the training, and the people involved. Can we skip to key takeaways? Maryann, is that okay?
Yeah, absolutely.
Again, while these relationships aren't necessarily unlawful in theory, they can create significant risks for the company, especially when you've got a supervisor subordinate kind of relationship. Disclosure policies and prompt actions really kind of what we look at on our end. Maryann, what are your thoughts?
I think from the plaintiff's point of view, the consensual relationships is important. Like, because a lot of times someone will come to you and they'll be like, yes, I was dating my boss, but then things turn bad. And you think, oh, consensual relationship, once it starts, it's always consensual. But no, you just have to track and be specific about the point when it became non-consensual, either when she said no and he didn't listen, or when he retaliated against her when she rebuffed his advances. And again, don't just focus on ultimate termination. Retaliation can be in actions and words and the way that he yells at her or screams at her. All those things are facts you want to gather that say that even consensual relationships starting out can turn into a either quid pro quo or hostile work environment and retaliation.
Yeah. Right. Thank you.
Thank you, everybody. Thanks, Isla. It was so much fun to see you.